A default judgment can have serious consequences. It can affect your credit, lead to enforcement action, and allow the other party to recover money or property without your side even being heard in court. But in Queensland, a default judgment can sometimes be set aside. Usually, this happens where the defendant did not properly receive the claim, was not aware of the proceeding, or has a genuine defence with reasonable prospects of success. The court will not automatically remove the judgment simply because someone asks. The person applying usually needs to explain why they failed to respond to the claim, provide evidence supporting their position, and show there is a real issue that should be decided at trial. Timing is also critical. If you become aware of a default judgment, acting quickly is important. Delays can seriously damage the prospects of having a judgment set aside. In many cases, enforcement action may have already been underway. That can include enforcement warrants, redirection of earnings, seizure and sale of property, or enforcement hearings to investigate financial circumstances. If the court sets the judgment aside, the proceeding continues as though the judgment was never entered, and the dispute can then be properly defended. Applications to set aside default judgment can be legally and procedurally complex, particularly where service is disputed or enforcement has already commenced. If you have had a default judgment entered against you in Queensland, contact Stonegate Legal for a free 30-minute consultation.